I want everyone to meet Professor Miss Evelyn Wilson. She is a retired professor from the Southern University Law Center. She just received the Horatio C. Thompson Endowed Professor after serving 28 years. She writes in legal history because she wants to know why. And she studied Charles Hatfield to learn why he had the courage to challenge LSU in opening a law school. I'm more interested in the research that she has, so I'm just going to let her get started, and then hopefully we'll be able to ask her questions at the end. I know that I'm really excited, so if we can just give a nice little intimate moment.
It's 1946. All right, so I'm going to learn how to do this. It's 1946. You're in your last semester at Xavier University in New Orleans. You know that you want to attend law school. Your father died when you were 16, and since then you've had to support your family, your mother, your younger brother and sister, and now you have a family of your own. So you have a wife and a couple of young children. So you can't afford to go to Tulane, you can't afford to go to Loyola, but they wouldn't accept you anyway. You're a resident of, a citizen of Louisiana. Your foreparents came to Louisiana in 1824. In fact, one of your foreparents was a Native American, so has been in Louisiana longer than Louisiana has been Louisiana. You pay taxes, you've worked, in fact, you're currently employed at the post office. So you're making your contribution to the state. You're entitled to get the benefits of that contribution. In fact, not only do you pay taxes, but your grandfather was a tax collector. So you have a long history with the state. But it's 1946, and you want to go to law school. Southern University doesn't have a law school at this point. So to start your application process to the state law school with its lower tuition, you write your letter. January 10th, 1946, addressed to the registrar at LSU. I'm interested in matriculating in school. I understand that you have a school. Send me an application. If he had stopped at the first paragraph, he probably would have gotten an application in the mail. No reason not to send him one. He asked for one. Okay? But he went on to say, I'm graduating from Xavier. It's 1946. We know that if you attend Xavier, you're black. We know that if you attend Xavier, you can't come to LSU. Very courteously, I expect to hear from you. And he does. He gets a letter in return. So let's ask this question. What gave him the courage? That was my question. Why did you have the courage to send this kind of letter? You know what's going to happen. You're going to get a no. So why waste the postage? As I said, he worked in the post office, and two of his co-workers were also buddies and friends. So they spent time talking about politics, and talking about sociology, talking about the war, talking about Roosevelt. One was John Russo. He was a feature writer for the New Orleans Sentinel and other newspapers that were associated with the Pittsburgh Courier. Okay, so that was the black newspaper that had local affiliates throughout the country. The other was Frank Sippos. He was a white New Yorker who had come to New Orleans and was now working in the post office with Russo and Hatfield. So these serious political discussions made him aware, made him want to be a part of this movement to get rid of segregation in the United States. So he writes this letter, okay? And I apologize that it's small, but I want to draw your attention to this part right here. This is the letter back from the Dean of the LSU Law Center. As you know, the state of Louisiana maintains separate schools for its white and colored students. Louisiana State University does not admit colored students. Then he goes on to say Southern University, the state has authorized that university to establish and maintain a Department of Law. Okay, so ABER is giving the law as it exists. There is never any law that says that blacks can't go to LSU. In fact, in 1868, Louisiana's Constitution said that all schools are open to all persons regardless of race or color. So there was a statute in place, okay, until 1879, that clearly, a statute, a constitutional article that clearly said schools were open. Okay, 1879, the language was taken out of the statute, but there was never a statute that said that blacks couldn't go to LSU. It was just a practice, and that's why I talked about the book as customs. There's no law, there's only the custom that blacks would not go. I don't want to leave the impression that ABER was a bad person for writing this letter. Okay? He was the dean of the law school, and he wrote the letter responding to the reality of 1946. In fact, Southern had been authorized, 1888. Southern had been authorized to have both a law and a medical school. They had neither. Okay? The practice had been that the Southern states would not create alternative segregated facilities until there was a demand. So we'll see that word later, until there was a demand. So you need some student to say, I want to come to school, and then the state would go about making arrangements to see. So when the authorization came in 1888 for a law school and a medical school at Southern University, there was no appropriation. As ABER had instructed Hatfield, Hatfield then wrote to Clark. Felton Clark was then president of Southern University, and Hatfield wrote him a letter that says, I understand that, and he means the Louisiana State Department of Education, has authorized the establishment and maintenance of a law school. I want to come. I'm interested in going to law in the state of Louisiana. Well, he knew there was no law school here, but he sent the letter anyway. So the letter was sent January 26th. He didn't hear back for about 3 weeks, and so he sent another letter on February 14th. So you have to ask the question, why did it take Clark 3 weeks to come back with a letter that says Southern has no law school? Why did it take 3 weeks? He had to talk to people about it. He had to get a plan together. He had to decide. Clark was in a very precarious position. It's easy to look at him and say, well, he just lacked courage. But he was in a position where every single dollar that he got came from the state. And if he upset the people in the legislature, if he upset the powers that be, then Southern would get shut down. Okay? So he was walking a very tight road. And so it took him a while to figure out exactly what I'm going to do about this problem. He had to talk to some people and sort out what was the best thing to do about this problem. And so you see this slide here, Southern University does not have a law school. I think there's a way to enlarge zoom in. Is that what I want to do? No.
Yes.
Yes? Well, I'll just take my word for it. Notice the CCs on the letter. He sends one to Governor Jimmy Davis. Okay, remember, we don't create a law school until there's a demand. So he's letting Governor Jimmy Davis know there's a demand for the law school. He sends one to Superintendent of State Department of Education, John Cox. He sends another one to the chairman of the legal committee of the State Board of Education. He's letting them know, putting them on notice that we now have a demand. Okay, the practice is we don't build anything until we have a demand. He's letting them know there's a demand. This last person, I don't know what his position was in 46, but Gibson became the president of Northwestern State University in 47, okay, making them aware of the demand. But this is the part of the letter that I want to focus on. Okay? So I made it a little bigger. For your information, state the last session of the legislature, we talked about having out-of-state scholarships. Out-of-state scholarships. So what does that mean? Louisiana charges you a tuition for going to school, but if you go to school outside of Louisiana and you're a citizen of Louisiana, you have to pay an extra tuition because you're an out-of-state student. Well, Louisiana as a state had this, or it was the practice among southern states. You see this, might probably provide out-of-state tuition as several of the other progressive southern states are now doing. So those progressive other southern states would give you the extra out-of-state tuition part. So if you go to school in Minnesota and they charge you $300 because you're an out-of-state student, Louisiana would pay that $300. Some states were so generous that they would even pay your transportation to get you to Minnesota and out of the state. Okay? So that was the program, the out-of-state tuition program that was being considered. Progressive, right? This is my favorite picture from Days of Segregation. Louisiana still had a Plessy mentality. Okay? 1896, Plessy v. Ferguson says separate but equal is okay. If a state is providing services to whites and providing the same equal services to blacks, then it's okay. You don't have to integrate those services. You can provide them separately. Well, this is what separate but equal looks like in the South. There's a song about, I couldn't even get a cold drink of water. Okay, the electrified cooling fountain is not available for blacks. Look at the date on this case. Hatfield's letter is 1946. 1938, the U.S. Supreme Court has already said subsidy programs don't work. So in 46, when Louisiana is thinking about starting a subsidy program, the Supreme Court has already 8 years earlier said that's not enough. That is not separate but equal. These folks have to go live somewhere else. They can't stay in their home state. And in Louisiana, that's particularly important because of our civilian legal system. How are you going to get civilian training in Minnesota? Okay, you have to be. Oh, thank you, thank you. How are you going to learn civilian legal system in Minnesota? So it's particularly important that education be provided within the state. So the Gaines case says you have three choices. You can let blacks into your white state institutions. That'd be equal treatment, 14th Amendment, right? Let them in. Your second choice is to build them their own comparable school. Okay? So you can have separate, but you have to have something. You can't send them out of state. You have to keep them. And then your third choice is to close down your school. That's acceptable. Okay? You're laughing. Virginia did that, right? We're going to close our schools. We're not going to let our folks in. Okay? Virginia did that in 1955. So those are the three choices. The court said in the Gaines case, Mr. Gaines asked for a school some time ago, and he's been waiting 4 or 5 years for this school, and you haven't done anything to satisfy that demand. Remember, we're not going to build it till we get a demand. Well, you've had a demand.